All right, we have Mr. Kirk Jensen here, who's unrepresented. Mr. Jensen, would you come up and have a seat? Josh, you kind of inherited this. Mr. Jensen was originally charged with traffic violations. The matter was set for a jury trial for August 16th, I believe it was. We had summoned jurors and we were ready to proceed. Earlier that week, I believe August 14th, Mr. Marvin filed a felony complaint based on the same set of facts. So the matter was set for a pre-exam conference. Mr. Jensen has made every court hearing, but he did express that he wants to represent himself. I offered to appoint counsel at each stage of the misdemeanor proceedings, and again in this case, but he declined. So, Mr. Jensen, you still wish to represent yourself in this matter?
I wish to have this case completely dismissed.
Well, everybody feels that way. Everybody else who wants their case dismissed, raise your right hand. Yeah, that's unanimous. So that's not up to me. But the question is, I'm willing to appoint counsel for you, but you've represented to me at each stage you wish to represent yourself.
I do not wish to have any counsel.
All right. Well, then let's talk about where we are. Where's the complaint? The complaint alleges that on or about April 6th in Lockport Township, that you did obstruct justice by preferring a counterfeit U.S. passport and counterfeit international driver's license at the time of a lawful traffic stop, an attempt to avoid criminal liability for driving without a license. The way that is charged, it is a felony punishable by up to 5 years imprisonment and a fine of up to $10,000. The second count is possession of a reproduced, altered, counterfeit, or forged chauffeur's license. Operator's or chauffeur's license. That's a misdemeanor punishable by up to a year in jail and a fine of up to $2,000. Count 3 alleges that you had no valid operator's license, plain old no ops. Are also charged with a civil infraction of no proof of insurance.
And I object to those. I object to that being labeled as counterfeit on all of those documents.
All right. Mr. O'Bear, do you have any instructions here or a plea offer? Or?
So the offer would be if the defendant wanted to plead to count 3, operating with no license, it's the 90-day misdemeanor. We would recommend fines and costs.
I object to that, and I will not consent to that either.
All right, let me unpack that a little bit. All right, you're charged with a felony and you're charged with possession of a false or forged counterfeit license. You're also charged with no proof of insurance. The prosecutor would dismiss all of those charges if you plead to no valid operator's license with a fine and cost. You may be the first person in my 21-year career that objects to having all the felony charges dismissed for a plea to a $200 fine. Nonetheless, you object.
I object to the fact that it's been labeled as counterfeit.
All right, well, they're just willing to dismiss that charge. the allegation in count 3 is that you are operating a vehicle on a public roadway without having a valid license, sometimes called no ops or no valid operator's license. It's under 257301 of the Michigan Traffic Code. It's punishable by up to 90 days in jail and a fine of up to $100. It carries 2 points and it goes on your driving record. If you plead guilty to that charge, I'm going to fine you $225. I'm going to give you time to pay it, and the matter will be done. If you don't wish to plead to that, we're going to have a preliminary examination next Wednesday, where the prosecutor will attempt to bind you over to circuit court on felony charges and continue the matter for a felony conviction with potential prison sentence. So his offer is to just be done with all of it for a plea to no valid operators. That's, I frankly was kind of surprised by the generous offer, but that's what it is. So our options are to plead to having no valid operator's license. You could even plead no contest. You can plead no contest. You don't admit what happened, but you also don't deny what happened. You would allow or accept that a conviction will enter. You and I have a fundamental disagreement about what it means to operate a vehicle or what it means to travel. But if you want this matter to be over with, you can enter a no contest plea to no valid operator's license. If you want to reap the whirlwind, we can have a preliminary examination next Tuesday afternoon regarding the matter. What would you like to do, Mr. Jensen?
I don't accept any of that.
All right, the matter will be set for prelim.
And just to make it clear, this would be the third time that a charge of no operator's license has been levied against me, and I'm standing against it because those documents are valid, and I object to them being labeled as counterfeit.
Find out next week. So that will be Tuesday, September 5th at 1 p.m. Prelim. All right, your bond is continued. You're free to go.
And just a reminder of the civil case that is ongoing, and those who are named in that, yourself and Mr. Marvin as well. Just
Which
to make sure that
which civil case is that?
Civil case, the notices, and all the recusals and everything that's been filed into this case that I've been filing in. Just to make note of that it is, on the record.
Well, let's take a look. Oh, you filed a August 28th, which is yesterday. I got this. I didn't see it. Objection to the report and recommendation in the matter of civil case. You filed this in federal court?
This was done in a federal court, has a federal case number on it, and all the defendants are listed.
All right.
Along with the notice.
Oh, it's great pleadings. It cites Abraham and the Book of Nations and a bunch of other jabberwocky. But it has been filed in the federal court. All right, that's all a matter of record. It's in the file. And you've even got Hebrew letters in here. Okay, I'll see you next Tuesday at 1 o'clock. Yes? Yes?
I'm Mr. Jensen's transportation.
Yes.
And on the 5th, my wife has chemo, and I have to take her to that. Is there a way that we can put it off to the following week? If that's all right with Mr. Jensen?
That would dump the matter on Judge Pattison, which I'm sure he would greatly dislike.
Okay.
So I'm sorry, but we'll leave it for that date.
It would be the 6th that would work.
I'm open to any date at this point.
We schedule things at certain times and everything affects everything else.
I understand.
So no, it's next Tuesday, you could be done with this for $225. And so will be next Tuesday, sworn testimony in court regarding this matter. You wish to not have counsel, and we'll continue that. I'll make further record. At this point, I'm declining to recuse myself. This is just a straightforward matter. All right, next Tuesday, 1 o'clock. You can make your way here somehow. Do you need a bus pass? I'll give you that. All right, you're free to go. Good morning, everyone who's here live and who's watching remotely. We have several matters scheduled for 9:30. We're a little bit behind schedule. They're in the matter of People versus Douglas Diata, file number 231163OM and 231164 are pretrial conferences on misdemeanor dog ordinance violations of dog at large and dog bite. Deborah Davis from the prosecuting attorney's office is here on those matters. Mr. Diata was here 10 days ago or so, pled not guilty on those tickets, and the matter was set for hearing this morning. Also scheduled is file 231073GZ. That is a petition regarding a dangerous dog. We had one of these yesterday. A lady was severely bitten by a pit bull in Constantine, and I ordered that dog be euthanized. And the criminal charges were dismissed. Part of the delay here is we were trying to all get on the same page. The petition was filed without input from the prosecuting attorney's office by Animal Control Department. Kyle Merck is our current animal control officer, and he's had to hit the ground running here in Centerville. The case yesterday was filed by the Constantine Police Department with input from our animal control office. And then the prosecutor came in and helped resolve the case. Also present is Timothy Reed, who is representing the Miller family regarding this matter. So Mr. Diata was here, as I indicated, when I looked at my notes, on July 25th. He was here for the arraignment and pled not guilty on both charges. And I set this and an order to show cause for today, August 10th. The dog was unlicensed. He did provide vaccination records, and the dog was not neutered. We were to provide a police report to the defendant also, which I believe hopefully was done. The defendant claims he did not know, according to Deborah, that this was also a petition regarding the dangerous dog. In reviewing the file, there is a notice of hearing for 7/25. The proof of service, Kyle Merck attempted to serve Dr. Diata at this M66 address, but he doesn't live there. The dog is there, but they live in Battle Creek. We sent the court a notice of hearing. I gave him, or the clerk gave him one, a handwritten notice for today. And the complaint was filed by Kyle Merck on July 20th. A copy of that summons and the complaint was mailed to Douglas Diata at the M66 address, noticing the matter for hearing for today, August 10th, 2023. The prosecutor's office came into this somewhat late, and Ms. Davis said, I don't know that we're prepared to proceed with the hearing. Mr. Reed has some input he may provide also. So there are two things going on. You got a ticket for dog at large and a dog bite. Those are misdemeanors under the animal control law, and you pled not guilty to those, and those were set for a pretrial this morning with the prosecutor. The other matter is there's a petition to do something regarding this dog. It's alleged that that the dog was over 6 months old, was without a license on its collar, ran at large unaccompanied by its owner, and was not under reasonable control after January 10th and before June 15th. The dog attacked or bit a person, and the animal caused serious injury to an individual. And then the police report was attached. Did you ever receive that?
The police report?
And the petition regarding the dangerous animal?
No.
Do you receive mail at 6?
There is no mailbox at that residence. I had spoken with the court. I had spoken with Kyle, the officer. I had given him the address. The court date was sent to the 18.5 West Michigan address for our court date. We did receive that. So we have received correspondence from the court at that address. And that is the address that is on my license.
All right. And that's the actual address of your office?
That is, we have a loft above that, and that is where we receive all the mail.
Okay. So that's your lawful residence.
Correct.
So, all right. When we were here last, I didn't look at the record. I pled not guilty to both counts, set for a hearing on August 10th at 9:30. So there was notice that we were here. You indicated you had an RV there, you're not living there, and the dog is there, which is a concern Mr. Reed has, I think, wishes to express.
I would like to make corrections to that. I believe when I did speak, when I was in front of the court on the first appearance, I did let him know that the dog is always confined within the residence. And if we were not at the property, the animal was not at the property. Since this incident, I did inform him that we have put in an invisible fence around the entire property. And the dog can never leave the property as long as we're there, then he leaves with us. So that wasn't the issue. The dog was always confined. And even in the dog at large issue, the dog was never at large. I just was leaving my property and the incident happened. So the dog was never roaming loose. He was never outside the confines of the 6-foot gates. That was not the case.
Well, these cases are all fact specific. They're all different. Yesterday's case, the dog had been known to bite other people. And the dog had also killed a cat and barked all the time. A young woman who worked for the Commission on Aging was taking an elderly patient back to her home, opened the door. The dog came out of the door and severely bit her in multiple places. Pictures were hard to look at. And she agreed that that dog could be put to death. The criminal charges were dismissed. So there's a range of things that could be ordered here, including the euthanization of this dog, or some sort of security that it won't happen again. But as I understand it, the complainants live in close proximity to where the dog is, and you live somewhere else. And I'm not clear if the dog is there when you're not there. An invisible fence is one option, but I've had cases where dogs bolted through the invisible fence. It's not a fence, it's a electronic wire under the ground that sends a signal. And on more than one occasion, I've had a case where the dog, they were pit bulls, went through the fence. So we've got the criminal cases, and you always did deny that the dog was at large, but acknowledged there was a bite. Ms. Davis, what's your position here?
Well, this is complicated. I want to apologize to the court and the Deannas, and especially the victims and all the people that are here today for this hearing. We were not given notice of the hearing or a copy of the petition. We were not aware that it had been filed. The last correspondence discussion between our office through David Marvin and the Sheriff's Department was that we were not pursuing a petition regarding the euthanization of the dog or any other issues with that. We were still continuing on with the criminal case with the ticket. So this morning I was definitely caught off guard when Your Honor mentioned that there's a hearing, and there's certainly a large number of people here that are probably expecting to be given the opportunity to testify. There's a stack of letters that I was handed. I have not had time to read through them all. And then, as per usual, when I have an unrepresented defendant and we're doing a pretrial, I spoke directly with Mr. Diata and his individual that's here with him. They indicated that they were not aware that today was going to be a hearing where like testimony would be taken regarding what to do with this dog, whether it would be euthanized or some other measures that are provided in our ordinance, such as getting stronger fencing, an insurance policy, a multitude of things. So with that, I would ask that the portion of this case regarding the GZ case be adjourned so that we can A, get a copy of the petition, B, prepare our witnesses, which would probably include many of the people that are in here, and see that Mr. Diata would be given due process as far as seeing the petition and presenting his own case as to what should happen with this animal. In the meantime, I do understand that the presence of this animal at the location off of M66 is extremely upsetting and traumatizing to the victim. I would ask that the court consider I guess a bond condition that the dog not be permitted to be on that property until this case is resolved. I think that although it is going to impact the Diata's ability to enjoy their piece of real estate down here, it's not their primary residence. And based on the concerns of the residents and the victim, I would ask that the court consider that for this period of time until this case can be resolved and we can figure out what to do regarding this petition, that the dog just simply not be here in St. Joseph County until we can get this figured out. Thank you.
Thank you. The way this happened, I had some idea that this had happened. Judge Pattison was aware of it and he kept asking me if I had heard anything, and the answer was no. As I understand it, the prosecutor declined to do a petition, so the Animal Control Department petitioned on their own, which they could do under the statute, which started the GZ case, the dangerous animal petition, also issued the citations. The prosecutor was aware of the misdemeanor citations, but because they didn't participate, they didn't get notice of the hearing. Now, the two things are intertwined. I'm not completely clear that the defendant does not have notice of this hearing, but the problem is they're sending stuff to the M66 address. Officer Merck tried to serve them, wasn't able to do that. They were here with me face to face. We gave them some notices, and I'm not exactly clear what the clerk gave them, but there is a notice for a hearing for today, which preceded the ticket arraignment. So on July 20th, the dangerous dog hearing was set for today, which is August 10th. On July 24th, you came in for arraignment on the tickets. And I set the tickets for a pretrial at the same time as the dangerous dog hearing, which was this morning. So you obviously had some knowledge that there was a hearing set for today. The problem is I don't know exactly what you got. I received a number of letters that was sent to my secretary, and I have not read them because we aren't there yet. I did provide a copy of that correspondence to the prosecutor. Also, this morning handed you the same copy of the letters that I got yesterday. I haven't read them, but you have them. So there would have been some notice to you that we were having a hearing regarding the dog today. These are difficult, but we have a number of these every year. And I used to be the prosecutor, and I handled a number of them as prosecutor. And they are not easy. One size does not fit all. One size does not fit all. Mr. Thomas, I'll be with you in a minute. We're in another hearing. You're welcome to watch us, but we'll get to your case in a few minutes. Mr. Reed, do you have any input on this?
Yes, Your Honor. Thank you. May it please the court. TJ Reed on behalf of Cinda Miller. And per the ordinance it was written under, the court is correct. Any individual citizen, prosecutor, or animal control can file a petition. So we are actually joining on behalf of the animal control and adopt their petition. Understand, I think due process, the court touched on this, Davis touched on. Our system is based on due process, everybody having fair opportunity to be heard and to understand what's going on. So if there was a confusion as to the hearing date, as far as service goes, and we're talking about somebody's property rights, I do believe due process needs to be taken into account. Sounds like Ms. Davis is asking the court to maybe put this out a little ways to give everybody that opportunity so there's no claim down the road that they were not prepared. I do believe there's a balance to be struck here between property rights and protection of society as well as the victim in this matter. So what we'd ask is not take custody of the dog, not destroy the dog today, but just order that the dog be removed from the M66 properties, period, until further hearing can be had and the court can make a determination. If it's not the primary residence, the dog can be removed and just not held or kept there until the court has a full hearing. I believe that's a fair balance between due process and protection. Again, Mr. Diatta stated earlier that if they're not there, the dog's not there, which means there's a suitable place for the dog to go other than that residence. And so I would ask that the court make that order and on an interim basis adjourn, hold the dog. I mean, in most cases, the dog never is back at the house in an attack like this. This is not a dog bite. This is an attack and a mauling. Pretty serious at that. That will come out at the hearing for an offer of proof. So there's permanent damage done to the victim here, where surgical intervention is more than likely going to occur. Not to mention the psychological stress that goes on in this particular residence, and dog is right on the way out. She's actually avoiding driving through somebody's private property with permission to get out to the road to avoid driving by this house or this property. So I would have just asked the court at this time to adjourn the hearing. I think that's fair to the Diattas, to the prosecutor, everybody involved. However, we would ask that in the interim, in order to be placed on the record, whether it be a bond condition in the criminal matter or whether it be a condition on this adjournment, that the dog not be at the M66 property until further order of the court in this hearing can be had. Again, there are a lot of witnesses here. People are here. There's neighbors that have had their animal attacked by this dog in the past outside of the confines of the gate. So this is not the first time this dog has been aggressive. And again, there's two sides to every story, two banks to each river. We understand that. And that's why I think it's important that Mr. Diatta be given ample time to present his case as well. We're not here to try to ambush somebody that's not prepared. I think that the court.
Well, I just learned something I didn't know. There's an allegation that the dog had attacked other dogs.
Yes, one of the neighbor's dogs. There was actually photographs, I believe, sent to Mr. Diatta of the puncture wounds from that dog by Mr. Diatta's dog.
Were you aware of that, Ms. Davis?
I was not, Your Honor. I just asked Deputy Merck if he was aware. He said it was, to his knowledge, it was called into animal control, but then they said they did not need an officer. So I've instructed him to find out who the person is and get a supplemental report done so that it can be provided to the defense. And these, I'm assuming the letters that are written here probably contain further information that is going to be important. So we'll have to follow up.
An explanation to everybody. People write to the court all the time. You know, my son is a good kid. He's just got an alcohol problem. Please be lenient on him. Well, we're not supposed to read those. You can't just call the court up and say, hey, judge, I'd like you to do this. It's called ex parte communication. And you can't just talk privately with the judge without giving information to the other side. Mr. Reed was aware of that. So he sent the correspondence to my secretary so we would have it. But I haven't reviewed it and they haven't seen it. So I provided copies to the Diattas. But at some point, if there is a conviction, those letters are important. The judge can't hear about the case before it happens, but once it is convicted and it's time for sentence, then I can review that correspondence and look at it and consider it, and they have a chance to see it as well. But there are a couple reasons why it makes sense to adjourn that part of the hearing. One, all this correspondence just came in. The prosecutor just got it. The defendant just got it. There's now an allegation that there was another incident, at least one other incident regarding another dog, and there may be other stuff in there. They're entitled to know about that rather than just get ambushed at the hearing. And it may affect what I do with the dog. I don't like euthanizing dogs. Very often we will try to find an alternative, like moving the dog from the city of Three Rivers out to a rural area with a fence, or neutering the animal and having it go live with grandma in the country, those sorts of things. But from time to time, once or twice a year, the situation is grievous enough that I have the dog put to death. And so I'm not even sure what they're asking for. Now, right now, what they're asking is this dog not be on the M66 property. Mr. Diatta, what's your position regarding that?
I think that's unreasonable and unjustified with no evidence that the dog did something criminal or outside the realms on my property. Additionally, I have a fully functioning farm, hoop houses, and gardening that I'm out at that property 3 to 4 days all day. there is no way for my dog to be housed at the loft for that amount of time while me and my wife are out working constantly. We're at that property maintaining. We just had fences blown down. We're constantly maintaining trees. We're preparing to build a home there. So we're constantly out there resurfacing, doing construction. We're out there all day. We're 2-3 months from trying to go, full steam with building our home.
All right,
We're
now,
there
if I understand correctly, if you're not there, the dog isn't there.
Correct. If I'm not there, then he's usually there while we're at work. Because I'm only there.
There's not a time where the dog is at the property and there's not a person there.
Yes, my daughters are there, we're there, or my wife is there.
How old are your daughters? Are they like adults?
Yeah, 24, 25.
And also, the perimeter, Judge, is completely private, meaning you can't even see inside our property, the whole perimeter.
We have photos. It's 6-foot fences around the entire property. So the entire property is fenced in with 6-foot fence and then privacy screen. And then it's completely logged in with, several 100-pound logs around the entire perimeter on the inside. And now we have an invisible fence. There are 3 layers of defenses inside that perimeter. We have invisible fence, we have 6-foot privacy fences, and they're logged at the bottom around the entire perimeter of the property. We have photographs of that property. It is not an issue where the dog roams free, can step out of the property, can come. He had one exit point, which was out of the front of the gate. And now we have invisible fence, and he doesn't even get within 10 feet of that front gate anymore. That is the only exit once we put in all these security measures. The amount of time I spend out there is immense, and it's days if I have projects, if I'm working, and we're there constantly. As far as the garden and things of that nature, that pest control, pesticides, maintaining the garden, that's a constant thing. So when I'm leaving work, I'm usually out there. I'm out there constantly maintaining, checking in on the property. So to not have the dog present or not be able to have them there under my supervision for 12, 18 hours at a time is unreasonable, especially since he is secured. And I think if we're able to present, even in pretrial, how this actually happened, the court will see that this is a highly secured environment. This was a 10 to 15 second window where this happened, and it was a provoked incident, and just with me just trying to leave my home.
Provoked.
So once again, if I'm allowed to present my evidence, show you these pictures of our perimeter, show you the complete fencing with no trespassing and beware of dog signs, and the only time that gate is open is when I leave when I leave, okay? That 10 to 15 seconds is when this happened. This did not happen where he was running around, he was out loose. I was simply leaving to go get some gas, and this is when this incident happened. It was a 15-second window when my gates opened, and our neighbor got out of the vehicle and walked to the gate. This is not an incident of the dog was running around and she was at her mailbox and she was attacked at her mailbox. That did not what happened.
Okay, but it happened.
It did, absolutely.
So I don't care how many, what if she was dead? Well, I'm sorry, it's a 15-second window. It happened. So we have to figure out what to do about it.
Absolutely.
We can't undo it.
But to say I was negligent without allowing me to present evidence.
And I'm going to allow you to present evidence. I haven't made any finding at this point. I'm trying to determine what the course of action is. I have a vague idea where this is. I drive down M66 quite often. I think it's across the street from Omena Lake, just north of the old Wall meatpacking property. Is that where this is?
It is right on Wall Hill.
But not the exact specifics of it. Mr. Reed, do you want to speak further?
I would state that he makes the argument that the defense was there. Mr. Diatta was present at the time his dog mauled Miss Miller on common property of the association that is out there, whether it's an association near at the mailbox. He was right there with the dog when it attacked. Not really sure how you call that a provoked attack. It's an aggressive breed dog. Irrespective, it's a wild animal who's gotten out and bitten other animals in the past. He was present at the time this attack occurred. So the fact that he's at the property with the dog doesn't mitigate the danger and the risk. I think a hearing has to be held. He wants to, doesn't know about it, can't have a hearing, but he wants to present evidence. And I don't think evidence should be presented today. I do believe that it's reasonable request that the dog be removed from the property until the court can have a full thing, because as stated, it did occur. It happened. She was attacked. Mr. Diatta had to lay on top of her to stop the dog from attacking. Well, I mean, he wants to make statements of fact. That's an offer of proof that will come out.
Okay.
And so it lays on top. And so there's a lot of things that I think cast major doubt and shade over what Mr. Diatta is presenting to the court. And I don't want to get the cart ahead of the horse. down to the description of the dog as reported to the emergency room when she was transported there as to what type of dog committed the attack. So the idea that he likes his dog, wants his dog, that's all understandable. We respect that due process, but the court has a duty to protect the citizens of the county. And that fence, that barrier did not work here. His presence did not work. Therefore, it's presumed that that dog is dangerous. And if the court does not want to take it into custody, which we understand, just move it off that property. Take the dog off the property until a hearing can be held. And to complicate issues, one of the issues under the ordinance in the GZ case talks about insurance and putting insurance on the property. He doesn't even have insurance on the property out there.
Untrue.
He has an RV policy on the insurance, which is not true.
Well, all right. Again, we're not getting the facts. I mentioned this yesterday. Some policies won't insure certain breeds of dogs. Many homeowners' policies exclude pit bulls and Rottweilers and Dobermans and a few other breeds. I know a little bit about Akitas. In fact, talking with Deputy Merck yesterday, he has an Akita, and they're somewhat rare. They almost went extinct. They're large, they're powerful, and we don't see a lot of them. But people that have them love them. He loves his, but they're not like a Chihuahua or a toy poodle. They're big and they're powerful, and so there's some inherent risk involved in having something like this.
Your Honor, I
Yes.
just wanted to clarify, it's my understanding that he, Mr. Diatta, is a resident of Calhoun County and therefore was getting the dog licensed in Calhoun County. I'm not sure if that is happening.
Well, that would be something for the pretrial. I asked him to bring to the pretrial proof of license and vaccinations for the dog to share with the prosecutors. I'm not sure what the status of that is.
They are present.
Okay, and I have not reviewed those yet. But as far as, again, keeping things a status quo and protection of our society, if he has this residency in Calhoun County, the dog is licensed in Calhoun County, he has presumably insurance on his home and business in Calhoun County where this dog would be housed. I think that would be the safest route for right now until we can figure out what to do with this animal and the petition that has been filed.
All right. Thank you.
The law.
At this point, the court has made no findings. We haven't heard any sworn testimony for or against. I haven't reviewed the letters. I did review the petition and difficult looking at the pictures. The defendants own a parcel of property. They want to build a house there, and that's the kind of thing we want. People to come here and improve the property, build a house, make a life here. And as he represented, and I don't know all the facts, this was a brief incident where the gate was open. The dog didn't go under the gate, over the gate. I had a case earlier this winter where it was snowy and two pit bulls got under a gate and killed some small donkeys, miniature donkeys. It was horrible. And they were on somebody else's property. They were euthanized by the owner. He shot both of them, and he was justified. So those dogs got out of where they were supposed to be into somewhere they weren't supposed to be. And we've had a number of those. They killed some llamas. We've had some horrible cases. A young girl was killed by a pit bull. Another girl seriously mauled. So I take these cases seriously. And we had a young girl, her mother got a rescue Doberman. And the next day the Doberman killed her daughter in their home. So there can be serious consequences. But I haven't made any finding, and as Dr. Diatta argues, he has his rights as well. He's a property owner. He's improving the property. He has it fenced. Since our last hearing, he's put an invisible fence, which is an electronic process where the dog is required to wear a collar. So I haven't made any finding. Now when we get to that point, I've got several options. I can do nothing and say, well, everybody just get along. I can order some intermediate action, like this dog shall not be on this property. shall not come into St. Joe County, which just makes the problem somebody else's. I can order that the dog be neutered. I can order that the dog be required to wear electronic monitoring for the property at all time. I can order the dog be killed. So there's a range of things, and as I said, one size does not fit all. This date won't work because it's during the fair. But TJ, I have Cody Witten disturbing the peace case set for Wednesday, September 20th. It's an ordinance case with Ms. Halleck. It fell through the cracks and we put it in there. I'm hopeful that case will settle. So I could have the entire day of Wednesday, September 20th open, but that's fair weekend. So what?
No.
Mr. Reed might be busy on auction day, the 21st, but anyway, Miss Davis will be on vacation that week.
I wouldn't call it a vacation.
Well, she won't be here. She will be busy she's on the fair board. Her kids are very active in our fair, and the people that are here get it. People watching are like, what? And I don't know. Have you ever been to the St. Joe County Fair?
No, we're new to the area, so
Well,
we're yet
then
to.
you can experience it. But anyway, that could be a date, but it won't work. So let's see what else I've got. One of the problems is finding time to schedule something like this. Right now, Laura, it looks like I don't have anything at all on Wednesday, September 27th. Meaning people will be placed under oath and tell me what happened. You'll have an opportunity to be placed under oath and tell me your side of the story, present pictures, drawings, diagrams, receipts, anything you want me to know. And at that point, I'll make a decision on what to do. Also, we will continue the criminal pretrials for that same date. In the meantime, I'm not going to order that the animal be banned from that property. The animal shall not be there unless, what's your name?
Sierra.
Say that again.
Sierra.
Douglas or Sierra Diata are there. The dog shall have its invisible fence collar on at all time.
And can the DMs provide proof of liability insurance for that property too?
I suppose whatever insurance is there. As I indicated, they may not be able to get liability insurance for this, particularly after the insurance company learns it's bit somebody. Anyway, you did bring proof of license and vaccination.
Yes,
You shall provide that to the prosecutor.
yes.
Full copy or is it in that?
You can keep these, and this is, I printed this off my computer. Just to keep that.
All right, now, when we get here to the 27th, it will be a hearing. So anybody that would be a potential witness will be sequestered. Meaning you'll have to sit outside until it's your turn to come in and testify. Anyone that wants to come as a witness, just to watch, it's a public courtroom. I encourage you to come. This is also on YouTube. But we didn't do any evidentiary things today, but just so you know, I don't want to hurt your feelings when you get here. If you're here to testify, you won't be able to testify until it's your turn to come in. And so you're not influenced by testimony that somebody else gave. That's a common occurrence in trials. All right, Ms. Davis, anything else we should put on the record here?
No, Your Honor.
Mr. Reed? All right, Dr. Diata, I didn't ask, does that date work for you?
Hey, I'll make it work.
All right. We will address this further on all regards on September 27th at 1:15, right here in this courtroom. All
Thank you, Your
right,
Honor.
you're free to go. Thank you all for being here. Had a lot